people online. So I'm very pleased that the ICCBA is organizing this short meeting. It's not a training, as it says, because we only have 2 hours, and the topic is so big that it's a good start. We do that, and we will push to continue. So we have some speakers today. So I will present Denise, the ombuds. Yeah.
Nice to meet you.
Anand Shah is a council, and he's a ICCBA member from the executive committee. Sorry, and Mary, of course, that everyone knows Mary from OPCD. Peter also is there, so welcome. Myself, and I think you know me. Yeah. I will start. I will introduce shortly, and we will listen also all the presentation. I think we know more or less all each other, so let's take it easy. Ask questions, interact, and I think it will be good. At the end, we will try to take some notes, things that we need to improve. So that will be something to continue. Some presentation will be distributed also. So yeah, first of all, I'll ask myself, are we at risk in defense? I think yes, it's easy because everywhere, yes, in victims, of course, sorry, everywhere in private companies or ICC, misconduct, misbehaviors can occur. Welcome. Please have a seat, otherwise you can stand. You can find a chair over there, and please close the door behind you.
There are 2 chairs here, so one is missing. Ah, no, two are missing.
Yeah. Yeah. So I try to identify what kind of risk that we may have. It happens that I do sometimes in France some trainings in a private company on training on preventing sexual harassment at work, and I have this risk list, that before to talk to the audience to know, and in fact quite similar, in fact, the risk. So what kind of risk we identify? But first of all, is the job insecurity. The job insecurity, because we are not staff members, we have short contracts, we are for trials, so a short period of time. We have many interns. It might have some pro bono people are working, so it's the job insecurity and the young age also. Many, I can see that there are many young people working all together. So it creates some job insecurity. Different nationalities. We have the visa issue. For instance, if you stop your job at the ICC, if you're non-European, you have 10 days to leave the country. So that's all. This job insecurity can create some fear and vulnerability. Sometimes other factors, a recruitment by a referral, a network with a friend or a council refer to you. So also you think that you are devoted a little bit more than in a more open recruitment process. Geographic isolation, so some people come from far away. I'm talking also business trips when we go in missions, so we can be far away, and there could be factors of certain vulnerability, especially with sexual harassment at work. It happens sometimes in business trips, not only, but this kind of factors. The reluctance to arm a collective project. We work all together. When we file a final brief, it's a long preparation. We all work together. It's tense. And if I feel oppressed or we don't want to cause problems, we have this project to finish on time, and that it's a lot of pressure. Sometimes blurring boundaries between professional and personal spheres. Yeah. Sometimes we all know work together, and some people that they know outside also of work. And the relationship of intellectual fascination, that it's really true for very young lawyers, that they work for a superstar lawyer, for instance. They think that that's this fascination, and they might be agreed to accept a lot more than it will be. So all of these factors, I think, are relevant to understand that potentially we may be victims of misconduct at work. So we are going to, and I will give the floor to other people to speak, to talk about the legal framework. When we speak about misconduct harassment, what are we talking about and what the law is saying? At the ICC, we have a law, and we have kind of coming to have instruments, and Anand will present that. And the other participants will later on speak about all the information, how to prevent, because the best way to stop harassment or misconduct, of course, it's to file complex sanctions, but first is prevention. And if you are all aware of what's going on, that's the best protection. So thank you very much. Giving the floor to Anand.
Thanks so much, Audrey. I think at the ICC and also the ICCBA, things can sometimes move slowly. So I think it's and oftentimes a catalyst is needed to move things forward. So thank you, Audrey, for being a catalyst on this topic, bringing us all together. And I hope it'll be the first of ongoing consultations between all of us and with the court as well. And that is what's needed in this particular area to strengthen the framework that we have. I prepared a PowerPoint presentation. So for those of you up front, maybe if you can shift, you'll be able to view it a little bit better. Apologies for that. Is it possible to minimize maybe the screen on the right-hand side? Or I think if you just, let's see. Yeah, that's great. And this way we'll be able to see most of the screen. So what is the core subject that is bringing us together today? And that subject is what I'll refer to as prohibited conduct. So if you don't mind moving to the next screen. So this term prohibited conduct, it arises from an ICC administrative instruction that was issued in April of 2022. And it covers the types of conduct listed on the screen. So discrimination, harassment, including sexual harassment, abuse of authority, sexual exploitation, and sexual abuse. That's in another AI that was issued in 2023. And also retaliation for reporting prohibited conduct. And the definition for retaliation, an updated version, was issued in a presidential directive in 2024. And it might be, maybe it's helpful I mention, what is the legal basis of administrative issuances. So I think we're all aware that the legal framework of the court includes many different types of documents. There's, of course, the Rome Statute, the rules of procedure and evidence, the regulations of the court, the regulations of the registry, the code of conduct for counsel. There's a code of conduct for the prosecution. And another area of law are administrative issuances. There's presidential directives. I think that's sort of the highest level if you want to look at it in that sense. You also have administrative issuances, which are generally issued by the registrar and oftentimes in consultation, or usually in consultation with the other organs of the court. And there are also documents called information circulars, and I frankly don't know too much about those. But the legal basis comes from the Rome Statute, the mandate authority granted to the president and presidency of the court, and also to the registrar to ensure that the court is functioning well and properly and in an administrative sense. So that is the legal basis for these types of documents. So let's discuss very briefly at least some of the definitions that are set out in the 2022 AI on these particular types of conduct. So maybe if you don't mind moving forward again, thank you so much. So firstly, discrimination. Discrimination as it's defined in the 2022 AI is unfair treatment or an arbitrary distinction that's based on a shared characteristic or trait. And the AI lists various types of characteristics or traits, race, gender, religion, etc. It's a non-exhaustive list. And I think one way to look at these shared characteristics or traits, they are I would use the word immutable in English. It's something that's core, that you either can't change or it's core to your identity. So it's a shared characteristic or trait. And this can manifest as an isolated event affecting one person, or it could be a group of persons. And there's also a connection potentially to the conduct of harassment and abuse of authority, which we'll move to now. If you don't mind, thanks. So this is harassment, and as set out in the 2022 AI, it's unwelcome conduct. So unwelcome conduct that can be reasonably be expected or be perceived to cause offense or humiliation. And an important aspect of this sort of element is that the intention of the alleged offender does not define whether or not something is harassment. So you're looking at it at least partially from the standpoint of the alleged victim. Additionally, it must be conduct that interferes with work, is made a condition of employment, or creates an intimidating, hostile, or offensive work environment. So I think that fairly broadly, broadly captures the context in which harassment takes place. It should be connected with work, but work is defined in a broad manner. It can be an isolated incident or occur repeatedly. There are many forms, and again, it's a non-exhaustive list that the AI sets out. Words, gestures, or actions are the broad sort of categories you can look at, and it can also be directed at one or more persons based on a shared characteristic or trait. So it has this intersection potentially with discrimination. And there is, the AI also specifically addresses sexual harassment, and that is a subset, falls within harassment, and it has some additional elements or characteristics. So again, it's unwelcome conduct of the sexual nature. It fulfills the other elements of harassment that we just discussed. Of course, this connection to the workplace and what an individual might reasonably expect or perceive if they're the alleged victim of this sort of conduct. And it can occur in the office or in connection with work. So it can occur if you're traveling on mission. It can occur in the context of a work-related social event. So again, in principle, this work connection is broadly defined. So if it's somehow connected to work, it may constitute sexual harassment. And once again, it could be a single incident or a pattern of conduct. And importantly, the perspective of the person targeted shall be considered in assessing the reasonableness of expectations or perception. So again, you are, at least one of the elements, you're looking at it from the perspective of the alleged victim. How are they perceiving this? And again, the intention of the alleged offender, that in and of itself will not define whether or not something constitutes harassment or sexual harassment. And again, there's a wide range of activities that could constitute sexual harassment. It could be verbal or nonverbal, physical or non-physical in nature. It could be a written communication, something that's said, certain types of behavior. So again, in principle, the AI defines the conduct or potential conduct in a broad fashion. Move to the next slide. Abuse of authority. So this is the other sort of broad conduct that is addressed in the 2022 administrative instruction. And that is defined as the improper use of a position of influence, power, or authority against another. And the AI states that it's particularly serious when abuse of authority is used to improperly influence career or employment conditions. Whether you're recruited, whether you're promoted, what sorts of assignments you're issued. So in this context, if there's an abuse of authority, the AI considers it particularly serious. And it may also include conduct that creates a hostile or offensive work environment, including things like intimidation, threats, blackmail, or coercion. And the last subject I wanted to, or type of conduct that I wanted to highlight was retaliation. So retaliation is mentioned in the 2022 AI, but as I had sort of noted earlier, this particular definition was issued in a presidential directive in 2024. And that supersedes an older presidential directive that had set out the definition of retaliation. So for our purposes, it refers to any direct or indirect detrimental action or inaction that adversely affects the employment or working conditions of an individual, where this action has been taken for the purposes of punishing, intimidating, or injuring an individual because they engaged in an activity protected by the AI on discrimination, harassment, or abuse of authority. So they have filed a complaint, a report, or they've sought the assistance potentially of the ombuds, of the staff council, for example. If there is retaliatory action in relation to that protected conduct, then that can constitute itself the prohibited conduct of retaliation. And now, who are the persons that we are concerned with in relation to this topic? So our focus for the most part are external legal teams, and that's both teams that are funded through the legal aid policy and also teams that are privately funded. So everyone is covered and has obligations and protections in this area. It doesn't matter whether you are within the legal aid system or a privately funded team. So of course, we have counsel, associate counsel, and other appointed team members, assistants to counsels, legal assistants, case managers, investigators, etc. So that's external legal teams. In addition, we have other categories, ICC officials, heads of organ, staff members. And the 2022 AI also creates this category, or defines a category of non-staff personnel. And that includes consultants, individual contractors, interns, and visiting professionals. And then there are, let's say, other persons, anyone else who doesn't fall in these three categories, who might be impacted by conduct that is prohibited under the ICC legal framework, witnesses, victims, even visitors to the ICC. So it's helpful to maybe keep these various categories in mind as we continue with our discussion. So I think the ICC legal framework that is applicable in this area, it can be divided into the pre-2022 administrative instruction and the post-2022 AI. So those are the two periods that I'd like to discuss with you. So pre-2022, the only documents that were of relevance in this area for external legal teams, there's the Code of Professional Conduct for counsel, and that was issued in 2005 by the Assembly of States Parties. So it's a resolution that promulgated the Code of Professional Conduct for counsel. There's also a Code of Professional Conduct for investigators. That was issued in 2008 via administrative instruction. So I don't know if anyone here is an investigator. I'm sure you have investigators on your teams. So they should certainly be aware that they have direct obligations and responsibilities under a separate code of conduct. Now, the court did issue in its early days in 2005 an administrative instruction on sexual and other types of harassment, but that was deemed by the ICC disciplinary body for counsel, and we will discuss that body in a little bit. But in a case, the Julia case, that was, I think the decision was issued maybe in 2017. The disciplinary board made very clear that the 2005 administrative instruction did not apply in the context of the code of conduct. And if you look at the text of that AI, it specifically says it applies only to staff. And now we have, so we have this for the majority of the ICC's existence. This was the legal framework in the area of prohibited conduct that was applicable to legal teams. So in April of 2022, after I think a process of maybe it was 3 years, Marie, maybe even more, Marie will know better than I, the court was discussing internally a new AI to address prohibited conduct, because the 2005 AI was deemed to have been very outdated. The scope was very limited. The procedures were not were very behind the times, let us say, in comparison to other international institutions. So after a fairly long process and consultations between the organs, and also consultations with the ICCBA, Maria and I were involved in that process, and I think maybe we had some very small successes in terms of the ultimate text of the AI. But that AI was promulgated in April of 2022. And in addition to this 2022 AI, I had also mentioned an AI on prevention of sexual exploitation and sexual abuse. That was issued in 2023. And as I mentioned, there is a presidential directive on retaliation. So that was issued last year. And so this is now the core legal framework at the ICC governing prohibited conduct post April 2022. So I want to discuss just a little bit the pre-2022 AI legal framework as it relates to legal teams, because that framework still has relevance today in the post-2022 regime. So under the Code of Conduct, counsel and an associate counselor are directly implicated. They have direct obligations under the Code of Conduct, and if there is an alleged violation, misconduct that is allegedly committed, there is a disciplinary regime established under the Code of Conduct that they can then be subject to. And as I mentioned, defense investigators also have the Investigators Code of Conduct, and they can also be subject to investigation and sanction if there's an allegation of misconduct on their behalf. But in terms of all other team members, there is no direct obligation under the Code of Conduct. There is no disciplinary regime, there are no sanctions that are directly applicable to all other legal team members. Now, the Code of Conduct seeks to address this indirectly in Article 32. And Article 32 states liability for conduct of assistants or other staff. And it says, counsel shall be liable for misconduct under the code by his or her assistants or staff when he or she orders or approves the conduct or knows or has information suggesting that violations may be committed and takes no reasonable remedial action. And the second part of that article states counsel shall instruct his or her assistants or staff in the standards set by this code. So under the Code of Conduct, counsel and associate counsel are directly responsible and liable.
Je ne vous vois pas sous l'écran.
Oui, je viens de voir ton.
Oui.
Oui, je viens de voir ton mail.
Oui.
Mais écoute, je me suis pas mise.
Someone can mute.
En anglais, hein?
All right, yes, let's move on, yes. And then if you don't mind moving to the next screen, sorry. Okay. Okay, there we go. And so how has this regime worked in practice, this pre-2022 AI regime under the Code of Conduct in relation to legal teams? I think many of us will be aware that in addition to this, the case of Mr. Tajunga from 2017, there have also been two recent cases before the Disciplinary Board and the Disciplinary Appeals Board against counsel in this subject area, in the area of prohibited conduct. Now, these decisions or the case record is not in the public domain at all or in full. So I think we'll have to wait and see when those disciplinary decisions are made public, how the disciplinary board dealt or addressed or interpreted the 2022 AI. But my understanding from what is available in the public domain is that the conduct in question in these two recent cases, it took place primarily before April of 2022, so before this AI was promulgated. So it would not have any direct relevance for the code of conduct. And the key question, and that's something we'll mention again, is whether or not the board, the disciplinary board, made any explicit findings as to whether the 2022 AI is directly applicable or something that can be referred to in disciplinary proceedings. So that is an issue that I think is a big question mark, and we'll see how the disciplinary board deals with that when we do have public versions of the decisions that I understand have been issued. So in the disciplinary cases that are in the public domain, the disciplinary board has found that what we refer to now as prohibited conduct is something that is prohibited under the code of conduct. And they found this in relation to several articles of the code of conduct. Firstly, Article 7.1, which covers the professional conduct of counsel. So counsel shall be respectful and courteous in his or her relations with all other individuals involved in the particular proceedings that counsel is appointed in. So respectful and courteous. Under Article 5, counsel must give a solemn undertaking before they take up their mandate before the court. And this solemn undertaking includes a declaration that they will act with integrity and diligence and act honorably. So integrity, diligence, honorably. And finally, the disciplinary board has referred to Article 24.1, counsel's duties towards the court. And that includes that the duty that counsel shall take all necessary steps to ensure that his or her actions are not prejudicial to the ongoing proceedings and do not bring the court into disrepute. So those provisions are the provisions that the disciplinary board has used to capture capture prohibited conduct effectively. So even though they haven't necessarily defined that conduct as constituting harassment or abuse of authority or discrimination, for example, they have found that effectively counsel can be found liable if they do commit prohibited conduct under these particular provisions of the Code of Conduct for counsel. You can move on, thanks. So let me just speak briefly about how the disciplinary regime works before the court, and this is a very basic explanation. There's much more that can be said about this process. So firstly, how do you submit a complaint? A complaint, again, a complaint can only be against counsel or associate counsel, but it can, as we just discussed, it could also implicate the actions of other persons on the legal team. If in fact counsel encouraged that behavior or was aware of that behavior and did not intervene. And of course, I've also mentioned that defense investigators are also directly implicated under the Code of Conduct. So for an individual to submit a complaint, it has to be submitted to the registrar. And that is done through the Secretariat of the Disciplinary Board. And the language in the Code of Conduct is that the registrar shall transmit this complaint to the commissioner of the disciplinary board. So at least my understanding and interpretation is that the registrar and the registry does not have discretion in this area. That's the way I read it. I don't know how things frankly have worked in reality, whether there has been any sort of gatekeeping function, because all of this takes place in a confidential setting. Now, and the information, so that there is on the court's website, you can find information on the disciplinary board and the Secretariat of the Disciplinary Organs, the email address and mailing address as well for them if you do need to contact them. So who is entitled to file this type of complaint to the registrar? Well, it can be a chamber dealing with the particular case in which the alleged misconduct took place. It can be the prosecutor, again, dealing with the particular case in which the misconduct allegedly took place. Or it can be, and this is important, I think, for most of us, it can be any person or group of persons whose rights or interests have been affected by the alleged misconduct. So in principle, I would view that as a fairly broad category of individuals. In addition to that, the registrar has the authority on his own initiative to submit a complaint to the commissioner of the disciplinary board. Now, the commissioner of the disciplinary board is effectively the prosecutor within the ICC disciplinary organs for council. And the commissioner is, if I'm not mistaken, appointed by, I think, the president of the court. I can double check that. I believe it's the commissioner is appointed by the president. I think they serve maybe a 5-year term, maybe it's a 3-year term. So they are responsible when a complaint is filed to then move that process forward. So how does that work? Well, if a complaint is filed, in principle, it is forwarded to the registrar. The registrar will then transmit that complaint to the commissioner. The commissioner notifies the council concerned, and that council is then entitled to provide a response within, I think, a fairly limited amount of time. It might be 30 days. Once the commissioner has received that response, they have the discretion to either dismiss the complaint if they believe the complaint really doesn't have any merit, or commence an investigation. If they do decide to commence an investigation, they must then submit a report on the outcome of that investigation to the disciplinary board. And the disciplinary board is made up of 3 members of the list of council, and they are elected by the other members of the list of council. There are, I think, 2 permanent members of the disciplinary board, and the 3rd member of the disciplinary board in any particular case is supposed to come from the national jurisdiction of the council concerned. So the commissioner would then submit this report to the disciplinary board, and there is also a possibility of reaching what the code refers to as an amicable settlement. So perhaps there's some sort of discussion between a council who has had a complaint filed against them and the commissioner. Maybe they come to some sort of understanding, they take some remedial action, and that it doesn't necessarily end the case, because in the end that settlement does not bind the disciplinary board. They can still take action under the code of conduct. But at the very least, this report must be submitted to the disciplinary board, and once the report is submitted, you have a disciplinary hearing process. And after, so there are, there may be some written filings that are made. There is then 1 or more disciplinary hearings. These hearings are generally held in public, and that's something we can touch on later on. And then the disciplinary board will issue a decision determining or deciding whether council, in their view, has committed certain types of misconduct, and if they have, they can issue certain sanctions for that conduct, anything ranging, for example, from a public admonition to striking someone from the list of council temporarily or permanently, and there's a possibility of issuing fines against council. There's also an appeals process. So that, in short, is how the disciplinary regime works. There's much more that could be said on that, but just I'm hoping that everyone now has a better understanding of how that process works. I can move to the next. Yeah, thank you. So what changed under the this 2022 AI? So this is the AI that we've discussed on discrimination, harassment, including sexual harassment and abuse of authorities. Well, firstly, these particular definitions were either updated or promulgated, the definitions that we have now discuss these different types of prohibited conduct. So the 2005 AI that was applicable prior to 2022, as mentioned, that was quite limited and quite out of date. Secondly, the scope of obligations and protections under the 2022 AI have expanded to include pretty much anyone who is connected to the court or comes in contact with the court. So it includes officials of the court, staff members of the court, heads of organs, counsel, and unfortunately this is something that Maria and I and the ICCBA were not successful on. The definition of counsel under the AI, it's counsel and all members of their teams. So we think that's a bit silly to use that terminology, but so just keep that in mind. When the AI, 2022 AI refers to counsel, that includes all counsel and all members of their team as well. And it extends to also non-staff personnel, as I mentioned, for example, interns, visiting professionals, contractors, etc., and any other person who might be impacted. So the AI states reports of prohibited conduct can be submitted by any person against any person, irrespective of whether such persons have a contractual status with the court. So this AI, in principle, its intention is to expand its protections to anyone who might be injured in this area of prohibited conduct connected with the court. It also sets out certain obligations on the court as a whole, heads of organs, and also supervisors. But it's important to remember in the context of the AI, supervisors are, that terminology is limited to supervisors in the context of the court. So staff members of the court, etc. That terminology does not extend to counsel. It also provides support and avenues for resolving prohibited conduct in addition to informal resolution possibilities. And I know that's something that Dennis will be perhaps addressing in greater detail and greater length. So what are some of these big principles that are set out in the 2022 AI? Firstly, the ICC states that it has a zero tolerance policy on prohibited conduct. And article or section 1.2 of the AI reads, the court will not remain silent or passive in the face of reported incidents, regardless of the offender. The court will actively work to protect and support affected individuals and ensure appropriate accountability for prohibited conduct. So this is a big, broad statement, an undertaking that the court is setting out in the 2022 AI. So what are some of the obligations on staff and non-staff personnel? And I exclude counsel here. So counsel, it's important to note, and other members of the legal teams do not fall under these particular obligations under the 2022 AI. But when it comes to staff members of the court and non-staff personnel, interns, VPs, etc., some of their obligations include familiarizing themselves with the administrative instruction and all other relevant court policies, that they attend mandatory training on prohibited conduct and other learning opportunities in this area, that they themselves take on to demonstrate a commitment to zero tolerance, that they take action if they witness prohibited conduct, and the AI states, provided they feel comfortable doing so and where possible after consulting affected individuals. And another important obligation is that staff members and non-staff personnel report suspected prohibited conduct and cooperate with investigations. So I think we have sort of an interesting dynamic here, wherein in theory, and again, this would be my reading of the AI, and maybe others would differ in this area, but a staff member of the court who becomes aware of alleged prohibited conduct, misconduct by counsel in the subject area, or a legal team member may have an obligation to report that under the Code of Conduct for Counsel, under that process. Whereas legal team members, including counsel, in principle under the AI, none of these obligations apply to them. move forward to the next, thank you. And the 2022 AI also sets out certain proactive obligations on behalf of the court, proactive and I think systematic approaches. That's the way I would qualify it. For example, the AI states that the court shall take appropriate measures to promote a harmonious working environment and protect, among others, and protect staff members, non-staff personnel, and other individuals from prohibited conduct through preventative measures as set out in the AI. And again, I would read other individuals to include counsel and members of their team. Additionally, there's an obligation under the AI for the court to develop standards, including a program for regular training, and to raise awareness of issues relating to diversity, respect, and equality, and to build skills on bystander techniques for intervening in situations of prohibited conduct for all staff members, non-staff personnel, and counsel. And counsel, again, defined in the AIs, including legal team members. Additionally, there is an obligation on the court to ensure that information and mechanisms are accessible to all staff members. And then we have a lot of legal language here, but states as well as to the extent possible and taking into account the terms and conditions of the contracts with non-staff personnel and other applicable policies. This obligation for information and mechanisms are extended as well to interns, visiting professionals, and counsel. Again, counsel meaning all legal team members. So these are some of the other proactive and systematic obligations that the court is setting out for itself under the AI. And my interpretation and understanding is that these obligations do extend to counsel and members of their team. For the AI also, so this area of support and resolution mechanisms, the main two avenues, in my view, under the AI are the ombuds, Dennis, and the staff counselor. So the AI sets out these general provisions as relate to both the ombuds and the staff counselor. Their services include discussing options and referrals according to the wishes of the affected individuals. That's the language in the AI. Any engagement with the staff counselor or the ombuds are done in strict confidence, and nothing will be shared without the consent of the person who is seeking the assistance. And there may be, I'm sure, some limited exceptions to that, which maybe Dennis can address. And another major principle connected to the confidentiality is that affected individuals, when seeking advice or assistance from the ombuds or the staff counselor, remain fully in control of this process. So the fact that you go to seek this sort of assistance doesn't trigger any other process within the court unless you consent to that process. And there are some more specific provisions in relation to the staff counselor and the ombuds that are set out in the AI. So the staff counselor is a mental health professional, and they can provide assistance in this area and perhaps referrals to seek outside mental health assistance if that is deemed necessary. Now, my understanding is that the staff counselor and any assistance that they do have, they have limited resources. That's my understanding. And they have the entire court to take care of, but in principle, this resource is available to all members of legal teams. The ombuds, there's a provision on informal resolution, and I'm simply going to read out what the AI states because I know Dennis will be able to explain this in a much better fashion than I can. But in the AI, there is language to the following effect. Affected individuals may, on a voluntary and confidential basis, attempt to address a situation of suspected prohibited conduct in an informal manner, including with the assistance of the court's ombuds. The services may include one-on-one conflict coaching to be able to give voice to concerns effectively, shuttle diplomacy to communicate with others through an intermediary without having to be in the same physical space, and facilitated discussions of mediation. So in principle, my understanding of this language is that the ombuds may be able to assist with informal resolution that an individual, a legal team member, for example, does not have to immediately proceed to filing a complaint under the Code of Conduct for Counsel. That informal resolution is a possibility. It's not a requirement. And certainly you could have informal resolution and also a formal complaint. So they are not mutually exclusive. So I think this is probably just I should have deleted this slide. It's just a repetition of the last one. You can move to the next one.
Yes.
So where does this take us? Everything we've discussed. How does the AI, the 2022 AI and other relevant instruments issued by the court, how does that interact with the Code of Conduct for Counsel, with legal teams? Are there gray areas? Are there gaps in the system? So as I've already mentioned, there is this question mark. There is this question mark, and we'll have to wait and see when we have the full record in the two most recent disciplinary cases, how the disciplinary board for counsel has referenced has referenced the AI and how and whether or not it's determined the AI is applicable directly under the Code of Conduct for Counsel. So that is a big question. But again, that doesn't mean that prohibited conduct is not covered by the Code of Conduct. We have discussed those particular provisions. Of course, I think we would all agree that optimally the AI would be directly part of this regime. And so we look at Article 31 of the Code of Conduct. It states, counsel commits misconduct when he or she, and this is one particular provision under A, violates or attempts to violate any provisions of this code, the statute, the rules of procedure and evidence, and the regulations of the court or of the registry in force imposing a substantial ethical or professional duty on him or her. Now, of course, there's no mention here of administrative issuances. They've been fairly specific. So I think this is the big question. And we'll wait to see how the discipline board deals with this. And the ICCBA certainly over the course of the last few years has been seeking to improve this regime. And we're looking at different ways of amending the Code of Conduct and taking other actions to ensure that the AI definitively is included within the Code of Conduct regime. So let's see how that turns out in terms of disciplinary board. So again, as we've discussed, the code and its investigation and sanctions regime does not apply to non-counsel team members with the exception of defense investigators. So that again is a very big issue. So in principle, every other, let's say, officials of the court, staff members of the court, non-staff personnel, and counsel and investigators are all subject in the event of a formal complaint to investigations and a potential disciplinary process. But that does not extend to non-counsel legal team members. And that is another area that the ICCBA and the OPCD as well are working to address, to fill this gap. And there may be various ways of doing that. One way may be amending the Code of Conduct, but that comes with certain complications because that is a code that in principle should only concern counsel. So it may be the case that the more effective way to do this administratively is to have another document that is issued specifically to cover the conduct of non-counsel legal team members in this particular area. So that is certainly something that the ICCBA is working on and will be consulting on with all legal teams as well. I also mentioned that there's no explicit reporting obligation for external teams in this area. And I personally think that is problematic. So maybe that is another issue that needs to be addressed potentially in the AI or through amendment of the Code of Conduct and any other document that may cover non-legal team members. there's no mandatory training for legal team members. So we saw the various obligations on staff members of the court and non-staff personnel, reporting obligations and training obligations. These training obligations do not extend to legal team members. So that is another issue that I think needs to be addressed within this regime. And it's great if the court does offer training in this area, if the ICCBA does, for example, but there's no obligation on anyone on the legal team side to undertake these trainings. So we can move to the confidentiality. That's something else I touched on. There are different regimes at the court when it comes to the internal disciplinary process of the court for staff members and non-staff personnel. As far as I understand, and maybe Marie, you're going to have much better knowledge on this than me, but those cases, those complaints remain completely confidential from start to finish. They, in principle, do not enter the public domain. That is not the case for the code of conduct process. A complaint under the code of conduct, as we discussed, it remains confidential until a hearing is held. And those hearings are in public. And while there are provisions under the code for confidential hearings to take place if it's deemed necessary to protect confidential information or the rights of an individual, including a victim, in principle, those cases are in public and the decisions of the disciplinary board are also in public. What the disciplinary board has done in the past, in the 2017 Dejunga case, they issued initially a decision that had no redactions. It named the complainant in that case who had suffered from sexual harassment. After certain litigation took place, the complainant litigated with the disciplinary board, and the disciplinary board then issued a redacted version of their decision. So that is another issue that I think we need to address within this regime to ensure that all interests are appropriately protected and balanced. Under the AI and the court's administrative regime, there is also a possibility for compensation for injury that is suffered in the course of service, including injury that might occur in the context of prohibited conduct. Nothing of the sort exists in the code of conduct regime, and that is yet another issue that the ICCBA is looking at in terms of potentially proposing amendments to the sanctions regime to allow for awards of compensation if that's deemed appropriate by the disciplinary board. And these obligations, these broader obligations that the court has taken on under the AI in terms of developing standards, in terms of training, in terms of information, and ensuring that mechanisms such as the ombuds and the staff counselor are made accessible. I think in my view, much more work needs to be done in this area. It does need to be made systematic. When, for example, if the court is offering trainings in this area to staff members, then I think, for example, that should automatically be extended to legal team members. So there's much more work and discussion that needs to take place in this area between legal teams, the ICCBA, and the court to further develop the system and make it more systematic. And I think that is my last slide. Can you confirm that for me? Yes, it is. So I know that was a lot of information. Audrey will send around this PowerPoint, so you'll have that to refer to. And again, the intention of that presentation was to provide just an overall view of the legal framework that's applicable in this area. So there's much more information out there, and we can now discuss that further, of course. But I hope everyone has a bit of a better understanding as to how the system works in this particular area for legal team members at the moment. Thank you so much.
Thank you.